Welcome to LegalBid, your fast pass for choosing legal help. The following video is for aggravated DUI Class 6 felony, DUI while there are minor children in the vehicle under 15 years of age. As you know, the state of Arizona is extremely harsh when it comes to DUIs. In fact, Arizona is one of the few states that you can receive a felony DUI on a first offense of being pulled over under the influence. Before we start speaking about DUIs, let's cover some definitions. According to Arizona Revised Statute 28-101.24, driving means to operate or be in physical control of a motor vehicle, meaning you don't necessarily need to be driving for an officer to use that word. The meaning under the influence means that the person is under the influence of alcohol, drugs, medicines, vapors, any toxins, or any substance that impairs a person under the slightest degree. Typically, in the state of Arizona, there are 4 ways that a law enforcement can approach you to start a DUI investigation. First is a traffic violation, like driving too fast, running a red light, etc. Second is by a welfare check. An example of this would be a car crashed in the middle of the road or a car parked on the side of the freeway, etc. Third is by a complaint or by a third-party observation. For example, a witness calling 911 complaining that a person driving too fast or weaving in and out of lanes. Fourth is a DUI checkpoint. Once the individual gets pulled over, law enforcement will ask questions such as, "Have you been drinking tonight?" or "Where are you coming from?" hoping you will say from a bar or something incriminating. In Arizona, along with most of the country, you have the right to prevent criminal incrimination. Therefore, it is your choice if you choose to answer that question. If you give incriminating comments, or even if you admit to drinking a drop of alcohol, you are automatically opening the doors for a probable cause to believe that you are possibly committing a crime. Usually, if you incriminate yourself, the next step is doing some form of field sobriety test. Some type of physical test that an officer may ask you to do are the following: horizontal gaze nystagmus, eye coordination test, walk and turn, one-legged stand. In the state of Arizona, it is not required for an individual that is under investigation of DUI to take any field sobriety test. Other evidence that the officer can use are visual and physical observations, such as slurred speech, bloodshot eyes, lack of balance, smell of alcohol, etc. A portable breathalyzer test, PBT, is not admissible in Arizona, but in most cases, officers around the state have PBTs handy. If you submit to a PBT, and if you blow a degree of alcohol over 0.04 for commercial drivers and over 0.05 for everyone else, it helps the officer to justify an arrest for further testing. After the officer is successful on piling up evidence against you, the next step is an arrest. A law enforcement will arrest you temporarily and collect a breath sample with an admissible machine, such as an Intoxilyzer 8000 or 9000. They also have the option to take a blood test, 2 vials, or a urine analysis, or all 3 of them. If you are at this point, Arizona has a law that is called implied consent, ARS 28-1321B, meaning if you refuse to take any of these tests, your privileges to drive will be suspended or denied for a minimum of 12 months. Failure of doing the test correctly may also count as a refusal. The officer might also tell you that if you do not take the test, blood vials or urine test or Intoxilyzer 8000 or 9000, they can obtain a search warrant and force you to take it. If it gets to this point, it may turn a bit ugly. While you are arrested, they will ask you more incriminating questions, such as, on a scale from 1 to 10, 10 being the worst, how intoxicated do you believe you are? As stated before, you have the right to prevent self-incrimination. Typically, after they are done with their investigation, the officer will conduct an arrest and book you in. Driving under the influence while having children in the vehicle under 15 years of age, Arizona Revised Statute 28-1383A3. This specific DUI is a Class 6 non-dangerous felony. When dealing with these types of cases, the individual is typically facing 2 things: the judicial procedure for an aggravated DUI Class 6, and possibly an investigation with the Department of Child Safety, DCS. We will only speak about the judicial consequences. If you look at the Arizona sentencing guidelines for a Class 6 non-dangerous felony, it can carry a sentence from 0.33 years to 1.5 years in prison. There are statutory provisions stating if it's the individual's first offense, then the person is qualifiable for probation. Aggravated DUI's Class 6 felony sentences must include at least the minimum sentence for what would otherwise been the misdemeanor DUI if the child had not been in the car. For example, if the individual is accused of an aggravated DUI Class 6 and their blood alcohol content is above 0.05 but below 0.15, then the felony 6 DUI minimum penalties will be treated the same as a misdemeanor DUI. Minimum of 10 days in jail, alcohol classes, treatments, fines. If your alcohol content is above 0.15 but below 0.20, it will be treated the same as a misdemeanor extreme DUI. If there are multiple children in the vehicle under 15 years of age, you will be exposed to multiple Class 6 felony charges. An aggravating part of a Class 6 felony is if convicted, there is a revocation of the driver's license for a period of 3 years. When facing a DUI charge, finding the right attorney can make all the difference. At LegalBid.io, attorneys bid to represent you, giving you the power to choose the best fit for your needs. Here's a breakdown of what you can expect. Option 1. Novice lawyer. Attorneys with 2+ years of experience in DUI law are eager to represent clients and build their reputations. These lawyers understand the legal process and are ready to take on your case. Their flat fees typically range between $4,000 and $6,500, trial costs excluded. Submit your case details and let these attorneys bid for the opportunity to represent you. Option 2. Experienced lawyer. With 6+ years of experience handling DUI cases, these attorneys bring solid expertise and courtroom knowledge to the table. They have a proven track record and are ready to help clients navigate their cases effectively. Their fees generally range from $6,500 to $10,000, trial costs excluded. Share your case and watch as experienced attorneys submit bids tailored to your needs. Option 3. Top-notch lawyer. These elite attorneys have over 10 years of experience in DUI law, with many being board-certified specialists. They bring unmatched expertise and a meticulous approach to building a strong defense. Their fees typically range between $10,000 and $15,000, trial costs excluded. Post your case details and let the top-notch lawyers compete to represent you. Next steps. Your journey to finding the right attorney starts with sharing your case details on LegalBid.io. Law firms specializing in your type of case and court jurisdiction will review your information and bid to represent you. You'll have the flexibility to compare bids and select the attorney who best fits your needs, preferences, and budget. Take control of your defense today. Let the right attorney come to you through LegalBid.io. We trust you've gained more knowledge and will make the best decision from the available lawyer options. Each attorney, from novice to experts, aims to achieve case dismissal or obtain the best possible result with the least exposure possible. Best of luck, and may you have a great experience using our platform.